Well, as you'll be aware, employment law has been a ripe environment for discussion in 2016. We've seen the implementation of the Health and Safety at Work Act, as well as the employment standards legislation in quick succession. The increased penalties that have accompanied both areas have meant that companies and those in governance have really had to turn their minds to internal processes and ensuring best practice compliance. And in short, these obligations have bite and for good reason. An issue which is currently before the Australian courts and which has already arisen in New Zealand is whether a parent company can be an officer of one of its subsidiaries as any other person occupying a position in relation to the business that allows the person to exercise significant influence over the management of the business. And the term person is defined in the Act as including a corporation sole and a body of persons, whether corporate or unincorporate. And the use of this term, as opposed to the reference to an individual, indicates that a company may very well be considered to be an officer for the purposes of the Act. But there's some uncertainty as to the correctness of this approach because the examples that are given relate to individuals. Another issue which has come out of the Health and Safety at Work Act is whether a director at board level of a holding company can also be an officer of one of the holding company's subsidiaries. And in our view, the answer is yes, and this has led obviously to directors being concerned about their due diligence obligations under the health and safety framework.